Welcome back. Let's get some perspectives on that matter. We've got Richard Nwakocha, who is an associate professor of public law in Rivers State University. He's also the MBA chairman. That's the Omoku branch chapter in Port Harcourt as well. Good morning, Prof, and thank you for joining us today. Could you go ahead and tell us? Yeah.
Good morning, Chamberlain.
All right. What, in your perspective, was the main reason why this stay of execution was granted?
The court gave the reason that there are several appeals pending from all parties in the suit, and that the court needed to give the order of stay so that whatever comes out at the end will not become nugatory. Realizing that the election is just next week Saturday, or is starting next week Saturday, the court felt it should preserve the possibility of a positive result becoming useful, as otherwise it will mean they are not on the ballot, the party is not on the ballot, and whoever wins at the end of the day is not getting any chance of contesting the election.
So can that also be described that the court was trying to ensure that they don't cause any irreparable damage by allowing the proceedings to go on while they haven't even gone to the substantive matter?
Yeah, I suppose at this point we can only guess what was playing out on the mind of the court, and I suppose from what the court has said, it was just trying to ensure that they can participate, because if you don't grant the stay, it means they won't be able to campaign, and if at the end of the day you agree that there is a candidate from any of the sides, then they would have entered into the election without campaigning. So this grant of stay of execution enables a party to campaign, even though as it is now, the party campaigns without a candidate, because the stay does not validate the candidature of the names on record. So where they are now is where they were before the Federal High Court was approached to compel INEC to obey the order of the court that had nullified their candidature. So it's actually a dicey situation for the APC. If election comes up tomorrow and they go into that election with those candidates, it means they are entering the election without candidates.
Prof, this might be a little ruffling, but in the build-up to this judgment, there's been a lot of accusation from various interest groups in the Rivers State elections that they know that ultimately the APC will be allowed, not, of course, considering the legal angles to all of this. So let me ask you, do you see this as a judicial decision, judicial judgment, or a political judgment? Because that's probably what the opposition is going to come up with.
Well, I think we can say both. We can say both because it's judicial in the sense that the court sees that there is a chance and possibility of a candidate emerging. And if that is the case, then it is legitimate for the court to try to open the window to the party, since at the end of the day, it does appear to the court that a candidate will emerge. For the political side, yes, their opponents will have to take it as something that has a political connotation. You remember we are in political times, and the issue we are talking about is a political issue, so everything definitely will have political value, and we're giving that characterization. But I think it's judicial. It doesn't say that anybody is the candidate. The appeals are going to be heard today. So the order of the court or the stay of execution does not validate any candidate. It does not say that APC has any candidate. What it has done is, as a party, keep the window open for the APC by allowing them to do what should be done at this stage before the election, in order for them to be able to, at the end of the day, if the court validates or if the court orders the candidature of any of the parties before it, then that party will have a chance of contesting in the election. At the moment, it has nothing to do with any of the candidates.
Do you see this, what do you think the implication could be, knowing that Rivers State is usually a hotbed during the elections? Do you see this judgment of the courts causing any uproar in the state, or do you see this as something that'll engender peace, in the forthcoming election in that state?
Well, I think ordinarily it shouldn't cause any ruffles. I mean, all parties that are involved in the election know they are going in for a contest, and Parties have been campaigning. Parties that had done things properly and selected their candidates have been campaigning all this while. They've had an advantage over the APC. So I think parties will have to build on the advantage they have had to make gains out of the long period they have had campaigning before APC has a chance to campaign. I don't think it can make things worse in the state.
But you know, the other matter that may be also decided on today at some point, do you suspect that it may also go the same way of that of yesterday?
Which of them?
I think I understand there's supposed to be another one in the High Court in Rivers. Is that going to happen today, you think?
No, I don't have a clear picture of that one. But yesterday, it's important to point out that yesterday, the court simply ruled on an interlocutory application. No judgment has been given.
Yes.
It is today that the court will begin to hear the appeals from all the parties.
Yeah, so
in that case.
The thing about that now is this. Much as, yes, it's an interlocutory matter, but there are those who suggest that, look, as much as this may be the case, isn't it also possible, because if they've not begun hearing the substantive matter, if groups or parties begin to delay this interlocutory matter, what chances will when will they then hear the substantive matter?
Well, considering that the court had granted a prayer for accelerated hearing, if it hears all the appeals today, we can only guess, if it hears all the appeals today, the court could possibly take the next date to give judgment, because what they have to do is adopt their papers, which they have filed, all the parties. And so on the next date, possibly, the court could be adjourning at the end of today for judgment.
But probably there's been some people who are, just going about with some legal permutations in terms of how this may eventually pan out. Because some of them suggest that, well, in the previous matter, because two judgments came forth from Justice Soho's Motoshaw's particular matter, and they were of the opinion that some of those cases did not actually hear the case as to the primaries, and they think that if it turns out that this becomes is an intra-party matter, all of what has been submitted before the court may just fall flat on its face.
Reason wouldn't, well, it won't be exactly that way. The reason is this. The inter-party matter was decided on the basis of the legal status of the party. And so if there's a change in the legal status of the party, that will automatically affect the one that was an inter-party affair. Because what was an issue was, in the present circumstance, the way they are, interpret whether or not they are in this election. So if the way they are changes, and there is a legitimate candidate that has emerged, it will automatically affect the outcome of the previous inter-party case.
What's your view of, because in some of the preliminary cases before they got to this point, they argued that the question of representation, some were of the opinion that, well, if the state's legal advisor was the one representing them at some point, and if the party has said, no, it's not supposed to be the state legal advisor, it ought to be the national legal advisor. And if the court did not hear that, and then they ask, in law, what kind of consideration do they give? Do they give more importance to the issue of representation than jurisdiction?
That is really the matter that is before the Supreme Court. So I think we may have difficulty going into that specifically. That is the substance of the matter before the Supreme Court, the appeal that is before the Supreme Court. Perhaps what is important is to point out that nothing happening at the Court of Appeal has anything to do with all of that, with the legality of the status of the candidates that were on the records of INEC before the last order by the Federal High Court, and by implication, the candidates that are on the record of INEC at the moment that judgment of the previous court had been stayed.
Okay, so
what you're asking about now is what the Supreme Court has to decide.
Okay, so let me leave that then and look at some of this other matter, because some are giving interpretation to this judgment. They feel, of course, the APC says, look, this automatically means that INEC should immediately put their name back on the ballot. Is that what it means, and what's the procedure for that to happen? Do they just rely on saying, look, if this has been given, then it means that they automatically should be on the ballot?
Yeah, I think technically or legally, that should be the position, because when an appeal court grants a stay of execution, what it has said is, let's revert to where we were before the last judgment was given. Do not implement the last judgment. Now, there is the argument that the last judgment has already been implemented, and so you cannot talk of not implementing because it has been implemented. But what it amounts to for INEC is that you have to put back the party on the ballot by the orders of the Court of Appeal, which is the supervisory court to the Federal High Court. By the orders of that court, you have to put the party back on the ballot. You have to revert to where you were, where things were, before that last judgment which you obeyed was made. I think it's important to understand it that way, because if election comes up tomorrow and you conduct the election without the participation of the party that has been given a chance to be on the ballot, that would have become an unlawful exclusion of that party.